Welcome to part 2 of our video series on liability risks associated with non-target pesticide application. These videos are directed towards agricultural producers, landscapers, and other pesticide applicators to help you better understand the potential legal risks associated with pesticide drift. In this video, I'll talk about the 4 main legal theories under which a pesticide applicator may be sued. My name is Jackie Schweichler, and I'm a staff attorney at the Penn State Center for Agricultural and Shale Law. A landowner whose property is damaged by non-target pesticide application may sue the applicator for strict liability, trespass, nuisance, or negligence. Strict liability claims are tort-based theories, and nuisance and trespass are property-based theories. Of those different liability claims, the most likely claim to be brought in this type of case is negligence. Negligence is the failure to act as a reasonable person would act under similar circumstances. The actions may be considered careless, thoughtless, or lacking oversight. Under the negligence theory of liability, there are 4 factors that a landowner plaintiff would need to prove. First, was there a duty? In pesticide application, the law imposes a duty on the applicator to follow certain instructions to avoid spreading the pesticides to non-target areas. The second factor asks whether there was a breach of duty. To answer this question, a landowner would need to review the standard of care for the pesticide applicator. The standard of care is what a reasonable person would do under similar circumstances. You can ask questions like, did the applicator fail to act in a reasonable manner to prevent damage from the pesticide? If the applicator did not apply the pesticide in the method described by the label, the applicator is almost certainly failing to meet the standard of care. In addition to following the label, the applicator must also follow best practices, as employed or used by others in their industry. Pesticide applicators, producers, and landscapers will be held to the standard of care relating to their specific business. It's up to a jury to decide the standard of care and whether an applicator breached that duty of care. The third factor in proving negligence is proximate causation. To determine proximate causation, the key question is whether the injury is a reasonably foreseeable result of the defendant's misconduct. The key words here are reasonably foreseeable. For example, if an applicator applies pesticides in an improper manner, it is reasonably foreseeable that the pesticide could damage someone else's property. The fourth negligence factor is actual damages. Did the pesticide actually damage property? If, for example, pesticide drift physically damages or inhibits the growth of grapevines, this would likely constitute actual damages. On the other hand, if some pesticide drift damages weeds in an abandoned, unused field, there may be a question as to whether this would be considered actual damage. For strict liability, a person is strictly liable for an injury if they are involved in something that's considered inherently dangerous, or if the activity could be considered ultra-hazardous. A popular example used in describing strict liability is the use or storage of explosives or hazardous chemicals. If strict liability applies, the injured party does not need to prove that the person was negligent or that they intended the injury to occur. In addition, a person can be liable regardless of how careful they were during the activity. Pennsylvania does not have laws specifying whether herbicide drift is a strict liability crime, nor is there specific case law to make this issue clear. That said, in Valari v. Terminix International Incorporated, the court stated that a factor in reviewing the ultra-hazardous nature of the activity is, quote, the extent to which its value to the community is outweighed by its dangerous attributes. In other words, to avoid strict liability, the community benefits from pesticide application must outweigh the danger of the pesticide, at least according to that case. The next legal theory that could be brought in a pesticide injury case is trespass. Trespass is defined as the intentional physical interference with the person or property of the plaintiff. Trespass also occurs when the defendant intentionally causes something to enter the plaintiff's land. A landowner who experiences pesticide injury could file a suit under the theory that a pesticide applicator committed trespass by allowing droplets of a pesticide to enter their property and cause damage. Even if the pesticide applicator themselves never physically enters the landowner's property, if the pesticide crosses the property line and causes damage, the landowner could potentially sue for trespass. Nuisance is defined as the interference or disruption of a person's private use and enjoyment of their land. In general, nuisance is an activity that is designated as harmful or annoying. An unwanted pesticide that causes damage to property and personal health could certainly disrupt the use and enjoyment of a property. In this instance, use of land could be interpreted to include the cultivation of produce, a home garden, or even routine outdoor activities. If herbicide drift damages a landowner's vineyard or flowering shrub, the landowner's use of those plants has been disrupted, and they could, therefore, theoretically bring a nuisance claim. In the next video of our series, my coworker, Brooke Dewar, will discuss the insurance considerations for pesticide application. Click on the link in the description or check out our page to find the playlist for our pesticide drift liability series.